Everybody. I would just like to thank my colleague Stephanie Thurber, who specializes in intellectual property, licensing, and that type of thing, who helped me set up the presentation. When the people at Above ask us a very simple question, does the Patriot Act apply to Canada? We gave them a very lawyerly answer. No, yes, maybe. Well, we have to justify our fees, right? So the answer to the very specific question, does the Patriot Act apply to Canada, is no. According to the Treasury Board of Canada, who deals with these privacy issues in Canada, there has been no application of the Patriot Act in Canada since 2001. However, Canada has very similar legislation to certain provisions that are covered by the Patriot Act. So that's the yes part. The maybe part is, as Leslie mentioned, is that Canada has entered into a bunch of mutual legal assistance treaty with various countries under the United Nations treaty network. So Canada will be called upon to assist countries for various matters, tax, evasion, money laundering, terrorism, criminal activities, to provide information, always in accordance with Canadian laws, to foreign countries. Obviously, the US being such a big trading partner to Canada, also just because of the geopolitical situation, Canadians have a tendency to collaborate with the US. But we have a very different approach to privacy rights in Canada. Being mostly under a British common law system, privacy rights have always been determined to be very important and a foundation of our legal system. It's been enshrined in our federal Canadian Charters of Rights. In Quebec, where Above is situation and carries on its business, we have a separate set of charter under the provincial laws of human rights and freedoms, and also under our common law, under the Civil Code of Quebec, we also have protection of personal information and what is called trade secrets, but which will include all commercial type of information from business process, contracts, client information, that also is protected. People in the banking industry are aware of two recent scandals. The HSBC, mostly on tax evasion, the HSBC case, as well as the Liechtenstein Bank, where the employee stole data information that it sold to the German government. Under Canadian law, Canada cannot pay, under our charter, Canada cannot pay an informant to get information. So currently, the Canada Revenue Agency is trying to use that information to impose tax on people who have offshore accounts. Those assessment and that access to information is now being challenged before the courts. So it's not an automatic that just because the government has access to information from abroad, that it will apply it. We have basically two separate systems to protect information. There's the personal information that will affect basically your clients, which are protected under the Federal Personal Information Protection and Electronic Document Act, the PIPEDA, which sets out rules that every Canadian company and business must comply with when dealing with personal information. there's restriction as to the gathering of information, how it's internally dealt, how it's protected, and how it can be disclosed. Those are the foundation of the core information system that the Canadian business have to deal with. And they're very restrictive. There's 10 principles that govern access to that information, and it's taken very seriously. So that applies to the private sector. Does not apply with any government information, which is governed by a separate law. All collection of information, whether it's by a Canadian company or through a supplier or a client of that information. So if a Canadian company has access to personal information of one of its clients, whether in Canada or abroad, that information is the protection of that act, of the PIPE, though, will extend to the information from the client, whether in Canada or whether offshore. Here it's important to have a difference between personal information, which will be, basically all information that relates to individuals, versus confidential business information that will deal with organization, which is not covered by that law. We have a similar law in Quebec, which has a very separate, a very distinct feature, is that a Quebec company cannot deal with a foreign supplier or subcontractor if the laws of the jurisdiction that governs that subcontractor does not provide for similar protection of personal and confidential information. So that is a question of principle. The problem with that law, as great as it is that there's not really any sanction to that legislation other than opening yourself to liability damages. So if you don't comply with that, there's no government sanction, but any breach of information, if you did not comply to provide the same protection that Quebec does, allows your client to sue you for damages. As I mentioned, the Patriot Act is not applicable in Canada because the Canadian government does not recognize the jurisdiction of the US to come into Canada and say, you know what, we've got national security letters, we've got search warrants, and so on to apply directly to Canada. But Canada has adopted a very similar measure in 2001. If everybody goes back, there was a knee-jerk reaction from all countries that kind of panicked and enacted these laws. Canada did, in fact, adopt a similar legislation called the Anti-Terrorism Act. As opposed to the Patriot Act, which seems to grow and grow throughout the coming decade, Canada's law had a sunset clause. So basically, when we adopted the law, we said it's going to apply for 5 years. After that, we will create a political committee to review whether that law has brought any more protection to Canada and whether we should keep it. And basically, after 5 years, in 2007, we said, we don't need that. We've got other legislation that will protect Canada and its citizen. We don't need that law that was a little bit similar to the Patriot Act and allow for government entity to provide, to allow search warrant without going through a judge or an administrative tribunal to obtain the right to do those search and seizures. But we do have similar legislation. We have the criminal code, which basically will allow a judge to issue a warrant to have access to any information regarding Canadian or foreign information that is accessible to Canada or under the control of a Canadian person. There's also the Canadian Security Intelligence Service Act, which is a little bit more like an anti-terrorism or anti-espionage type of legislation, which also provides the government to have access to certain information, but always under the guise of court supervision. So before the government can access any information, it must obtain the authorization of a court, the criminal court applicable in the jurisdiction in which the province the information is located, or in certain circumstances, administrative tribunal. For example, under the Income Tax Act, you need to, there's a special tribunal that deals with these issues. For example, under the Income Tax Act, there was this infamous eBay case where the Canada Revenue Agency went and asked eBay to give them the information regarding all sellers that had more than $100,000 in sales and were located in Canada. Well, the court said, you can't do that. That is too much of a fishing expedition. If you're going to have access to information, you're going to ask a disclosure of confidential information, you must provide us with a distinct person. Who are you aiming the search warrant for? And provide us reason as to why that should be done. Not because there's a suspicion that maybe there's tax evasion or unreporting of income or trade of illegal substance. That's not sufficient. You must provide us with reasonable grounds for why we should issue that warrant, which basically is a breach of constitutional right. As I was mentioned, there's no mechanism where, you know, Canadian CISS, which is the equivalent of the CIA or the FBI here, can just send a letter saying, give us that information. All information must be disclosed to a court. And in all cases, you can challenge such a warrant or a search and seizure order or a production order before a Canadian court. The basic principle is that there's no gag order. So if you get a seizure from information regarding a person, you can always advise that person that you received that production order or seizure. Unless, and then now the burden is on the government to say that that disclosure would cause harm to an investigation or national security, which seems to be fairly different than the standard under the Patriot Act, which a gag order is almost always applicable, but then you have to challenge the gag order. In Canada, the burden is reversed. It's the government that must provide reason why the judge or the administrative tribunal, when issuing the search warrant or seizure order, must provide reason why the seizure, the gag, must be subject to a gag order. So if it's under the criminal code, so we're talking about criminal activities. In Canada, all criminal activities, including Terrorism Act, are governed by the criminal code. So we don't have, you know, various legislation that was going to be applicable, all fall within that specific code. So then the government or police or the CSIS must provide that there is reasonable grounds to believe that a specific place has data or documents that relates to a criminal offense. So it's not, again, it's not what the Canadian courts use as a fishing expedition. These search and seizures are not investigation measures, but really are there to complete an investigation where the police has already established reasonable grounds that there has been criminal activities. Again, like as I mentioned, this is only governed where a court has issued the warrant. So there's not, the police cannot directly go to a person and ask for that privacy information. because, again, that's a charter breach. In fact, what's going to happen is that any person in Canada gets such a search warrant, the first thing that they do is that they call their lawyer. And the lawyer is going to say, ask for all information, documents, data, computers to be put under seal so that the authorities cannot have access to that information until you have a chance to challenge the validity of the warrant or the tribunal's decision that authorized that disclosure of privacy information. From that point on, then you can challenge the reasonable grounds on which the police presented to the courts to obtain their search warrant. We have a similar law dealing with anti-terrorism and espionage, on which is our, again, like I mentioned, our CIA or FBI. I'm not sure which one does which. But again, these rights that are given to that government agency are fairly limited. And for example, unlike in the US, my understanding is that for that law to apply, there must be a threat to Canada, not a threat worldwide. There might be some terrorism in some foreign country. There must be a direct threat to Canada, which will very limit the application of that jurisdiction. And also, which our understanding is that that section is more used, it's for espionage reason between countries, which basically does not really concerns private information, but to obtain information as to foreign nationals that are in Canada, which might do either some old spy stuff or corporate espionage, like we saw last year where a few Russian diplomats were expelled from Canada. It was under that legislation. As I mentioned, the Canadian law will always provide the right to advise the person whose information has been seized or breached to be advised that that has happened. So that person can always, with the Canadian person who had access, who had control of that information, challenge the use of that or that disclosure of that information which is under seal to the Canadian authority. So really it's a protection that applies before the government has access to the information and not after. It's what is called in law school in Canada, I don't know if the US is the same thing, it's called the toothpaste theory. Once you have a tube of toothpaste, once the toothpaste is out, it's very hard to put it back in. Here is the same thing. Once the government has access to that information, if a judge says, well, you know what, you were not right to get it, so therefore you cannot use it, but the government already knows about it, already has the information, so it's kind of hard to deal with that pre-disclosure and say, well, you had no right. In Canada, that is always prior to a disclosure to the authorities. So that allows us a greater level of protection for the person whose information has been disclosed. There are certain rights that the CSIS has to obtain warrantless wiretapping and also secret court orders. But our information, like Leslie was mentioning, is that that's very hush-hush spy stuff. But our information is that has been applied less than a dozen times in Canada in the last 12 years. So we're not talking about, I think your number was 192,000 orders that were sent. We're talking about 12. So we have a very different mindset of police and military enforcement than in the US. I think I kind of mentioned that already, that national security letters do not apply, and if a national security letter is sent to a Canadian resident, basically, you should not ignore it, but they're not enforceable. So unless, like Leslie mentioned, that the Canadian person has a U.S. presence on which those letters could be served, the U.S. cannot send a subpoena to a Canadian person in Canada and have it enforced. But that doesn't mean that they cannot try to get the help of the Canadian government to have access to that information. Canada, as most countries, are members of various mutual legal assistance treaties. There's one for criminal in most of the tax treaties that we have with various countries. There's help in getting access to information, as well as exchange of documents, extradition, help in providing assistance to anti-terrorism, but always under the guise of Canadian laws and our basic principle that privacy and confidentiality is a great charter-protected right. So what will happen is that the FBI or the CIA or whatever jurisdiction in your country will make a request to their Canadian counterpart to have access to certain information. Then the authority, the Canadian authority, being the Canada Revenue Agency, the RCMP, our national police, local police, will get that request and see how, under our Canadian legislation, that can be applied. So, for example, I think something that's very easy to illustrate, Canada does not allow the extradition of criminals that can be subject to the death penalty in any jurisdiction, and most often in Canada, because under Canadian charter rights, the government cannot punish by death. So by allowing extradition to the US, where that could be applied, that is not in accordance with our charter-protected right. So it's a bit extreme illustration, but I think it gives you the gist of what's going to happen and under what circumstances would Canadian authority allow the disclosure of information or force the disclosure information to foreign countries. And again, once that is done, even though the request of the warrant or the production order is under a mutual legal assistance treaty, the Canadian person on which that is served can always challenge the grounds on which that order or warrant was issued. Under our common law, under the Civil Code of Quebec, there also is an obligation for each businesses in Quebec to provide protection against disclosure of, here, not only personal information, but all types of information, from know-how, trademarks, licenses, business process. All of that is protected, and a Quebec person must provide protection of that information. The only reason where that is not applicable is where it's where there's security or health reason where that information must be disclosed. So there are various levels of laws that apply to protect private information, confidential information, trade secrets, business, commercial deals, from charter protection to basic common law contractual obligation to provide that information by a Canadian and Quebec person. If there is such a breach, and that breach is not reasonable, then you have various rights to get relief from that breach or unreasonable disclosure. So either it can be damages, you can get injunctive relief, so you can go to a court and say, some of my personal information has been disclosed. Court stops whoever person could use that information from using that in any form so that I don't have any damages or a recognition of my charter rights to that protection. Otherwise, you have a claim, a recourse against any person or business that did an unreasonable breach based on the actual damages that you have suffered. Sometimes the Quebec court will provide, or Canadian court in general, will provide for punitive or exemplary damages. But those are very rare. Unlike in the US where you have millions of dollars of damage issued, Canadian courts are more in the British tradition where you have actually damages that are suffered and not as to punish the person that did the breach. So basically, in conclusion, what is important for a Canadian person and or foreign person dealing with Canadian businesses is that foreign authorities do not have access to any information that is controlled or under the, for which a Canadian person or has access or control that information, unless that information is subject to an order provided by a Canadian court. So foreign legislation, as the Patriot Act, will not in and of itself be applicable to Quebec, but as we went through, there's a couple of laws that would allow a foreign authority or a foreign government to obtain the help of a Canadian government to have access to that information, but always under the guise of our more restrictive privacy laws. I thank you.